and I'm very happy that the Ninth Amendment, the right to privacy as it's derived from Ninth, Fourth, 14th Amendments, etc., would protect against those types of involvements from the government. 10th Amendment has to do with states' rights, giving giving the states and people generally the right to retain any rights not specifically given to the federal government. I would contest that this is an amendment which is more or less been legislated and Supreme courted out of existence. Generally, the federal government has been the one that comes out on top in questions of states' rights versus federal powers, going back to the Civil War and issues before that. States' rights were a major factor in the southern states' attitude about secession from the Union. They believed it was within their rights to nullify acts of Congress, just to kind of ignore them, or for states to do as they pleased in regards to federal law. But the Civil War started, I guess, deciding that question in favor of the federal government, as did a much earlier court case, Marbury versus Madison from, I believe, 1803, which put the power of declaring something unconstitutional in the hands of the court. It had not had that power up to that point. And to that point and beyond it, many states felt that they still had that right, which would be called nullification, whether states themselves can declare an act of Congress unconstitutional and nullify that. This comes out again in desegregation in southern schools, when the governor of Alabama was given instruction by Congress to desegregate. Arkansas rather, instructed to desegregate the school. He basically made an argument on the basis of the 10th Amendment and states' rights, that the federal government couldn't just do as it pleased or force this type of action on the states. And then the federal government went ahead and did force it through the use of deploying troops in order to forcibly desegregate the schools. So if you're from the South, you may be thinking, yeah, states' rights, go. And if you're from the North, you're thinking, what is the big deal about states' rights? Traditionally, that's been the regional divide, with northern or east coast states favoring a more federal approach, and the southern states looking more towards states' rights. The 11th Amendment, which I'm going to get to in this subcategory I'm calling early amendments, those passed within a few years of the Constitution and Bill of Rights. 11th Amendment granted sovereign immunity to the states. It issues whether giving the states the ability to discriminate against individuals or groups is at issue here. What was decided was that the judicial branch was not going to have the power to rule in lawsuits brought by individuals against the states. Some people, more recently, scholars, have seen this as basically the federal government saying, we don't have the time or energy to protect individuals or groups from state governments that discriminate against them. This has been tested in court one way or the other. 12th Amendment. This is a response to the emergence of political parties. Originally in the Constitution, the president was to be decided as the person who received the majority of the electoral college votes. and the vice president as the one second most. This is the way things ran for the first several elections. But as soon as political parties started to come to prominence, which is, to be honest, almost immediately, George Washington was the only president we've had who has not belonged to a political party. But almost right away, with the advent of political parties, we see that it would disrupt the functioning of government to have the president and vice president be the ones who just ran in the election against each other. So they changed it so that the vice president and president are on the same ballot. All right, Civil War amendments. These are ones ratified shortly after the Civil War during Reconstruction. 13th Amendment prohibits slavery. It's ratified the same year that the Civil War ends. It kind of makes the Emancipation Proclamation out to be a national law instead of just one of Lincoln's war acts as president, as it was during the war. So it actually gets written into the Constitution. 14th Amendment extends citizenship, due process, and equal protection to all those born in the United States, including slaves. The Equal Protection Clause has since been probably the most often cited constitutional basis for new cases, where this Equal Protection Clause applies more broadly to women, to other non-racial minorities, such as homosexuals or various other groups. So this not only gives the full measure of citizenship to ex-slaves, but becomes the basis for much more beyond itself. Some folks, scholars I should say, would go so far as to say that the 14th Amendment really created a new constitution because it defines citizenship more concretely and federally, and becomes the basis on which the process of incorporation starts to work, where the states more or less have to follow the federal government's lead in constitutional matters and in legal matters. So that citizenship is not really left up to the states to decide, but it becomes a almost entirely federal issue. The 14th Amendment obviously reverses the 3/5 compromise that was written into the Constitution. Slaves are no longer 3/5 of a person, but a whole person and a citizen. Reverses the Dred Scott versus Sanford case, 1857, which had denied citizenship to slaves and descendants of slaves, even those who were not slaves themselves. Generally, looking back, we see the Dred Scott decision as probably the worst thing that the Supreme Court had ever decided. Reading Chief Justice Taney's ruling is really strikingly racist, because he ruled that African, or those of African descent generally, were beings of an inferior order, unquote, who, quote, have or had no rights which the white man was bound to respect, unquote. So a pretty radically racist opinion by the court, as you can see from the date, just 4 years before the Civil War starts, and this is a major factor in that lead up to war. This amendment also relates to the Civil War in that it disallows anyone who had participated on the Confederate side in the war from holding any government office. 15th Amendment extends the right to vote to those who were formerly slaves.